Hello folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. So today again we will be continuing with the winding up of the companies, right, and referring to the provisions of the Companies Act 1956. So in the immediate preceding lecture, what have we covered? We had started with a very important topic. Why do I call the topic to be a very important topic is that in the past 10 years, around 10 years, you have been asked about that question around 10 times. So a frequency, if you say, it is 50%. That means in almost every alternate attempt, you have a question from this specific topic. I'm not talking about the chapter, I'm talking about this specific topic. Yes, I'm talking about section 529A and section 530. Right? And very specifically section 529A. The questions that are asked in your examinations, the practical question is asked from here, and that always depends on section 529A. Always, when I say always, means always. So far that has been the trend for the institute. Right? I will discuss the questions also with you, but meanwhile we'll continue with the provisions. So what did we cover in the previous lecture was the comparison between section 529A, section 530 and section 90 from the Debt Recovery Act. You remember? Yes, and we said that section 529A that was introduced in the Companies Act 1956 via the Companies Amendment Act 1985 would prevail. That is for the legitimate due of the workmen, right? So, in the lecture today, we'll start with section 529A, overriding the preferential payment. If you remember, in the previous class, I had showed you a slide containing 7-8 items about the preferential payment. I just showed you, I just read out the names, but we did not discuss anything about that. So we will be covering it today, right? So, as I have already informed you that you have been asked questions on section 529A a lot of time. That more than 10-15 questions have been asked in the previous attempts. Like previous all the attempts that I'm talking about, but specifically previous 10-12 years it has been asked 10 times already. Yes, I'll give you the list of the questions and the attempts when they were asked. Right? So when I start with this lecture with the discussion of the overriding preferential payment, I would again say that before starting with this lecture, I would read out one question that is asked in your CA final attempt recently in 2010. Right? Over there, they had asked you to explain the meaning of the term overriding preferential payment. So when I'm talking about this lecture, please pay attention and try to understand, because that is what you have to write it down in the examination straightforward. Otherwise, there is no other theory question. All the questions have been on the practical end, right? And we'll be discussing the practical aspect of this section as well, right? So let us start with that. So when we talk about overriding preferential payment, we are talking about two categories of people. One, the workmen, and the other, the secured creditors, right? So when we talk about the workmen or secured creditors would be covered only to the extent such that rank pari passu with the workmen due. Pari passu is one word that has been widely used in this section. Whenever you refer to the secured creditor, you always write that yes, they will be paid off their dues, their debts, right, to the extent such debts are ranked pari passu with the workman debt. Now what does this word, the Latin word pari passu, mean? It is PARIPASSU. So it means working side by side, equivalent, right? So your secured creditors will be compared to the workmen due, and equally to that extent of the workmen due, they will be put into the category of the overriding preferential payment, right? These things would come in or seep into your head once we start with the practical aspect. So before that, just listen to what I'm saying and try to absorb as much as you can, right? When we are going to when we move ahead to the practical aspect, that is the time when you will grab this concept very clearly, right? Now when we talk about the workmen due and the secured creditors, right, you need to know that yes, section 529A actually protects the right of the workmen, so that they are not deprived of the legitimate claim that they have, right? And we know that they will be paid in full before moving ahead to the payment to any other person. They'll be paid in full. But yeah, there are situations when they can't be paid in full. That is when the assets are insufficient to meet them. Right? And in such situation, when the assets are insufficient, for example, your workmen due with rupees 25 lakh and secured creditor rupees 100 lakh. So what happened is total is 125 lakhs and you have received money after you disposed of your assets somewhere around 80 lakhs. So how do you satisfy them? You can't satisfy the 45 lakh portion, right? So in that case, they shall abate in equal proportion. When I say equal proportion, does not mean 22.5 and 22.5, that the workmen get only 2.5. No, that is not the situation. When I talk about equal proportion, we talk about proportion. And we'll deal with the proportion word when we are doing the practical aspect of this section. Right? First of all, we need to understand what workmen mean. Right? And there are certain terminologies that we need to take over. Right? So first of all, when we talk about workmen due, we'll talk about workmen before that. Let's hide this again. So workmen are basically the labor category people, if we talk about. That is, in the plain text you can understand, labor category people. When we talk about labor category people, actually the definition of workmen are given in the Industrial Dispute Act 1947. 1947 at the time of the independence. At that time there was an act, Industrial Dispute Act, that defines the workmen. Right? I don't know how far has it been amended and how far is it going with the current scenario, but the payment that they talk about for the workmen due is that all the people who receive a wage of less than 6,500 fall into the category of the workmen, and 6,500 is obviously the monthly payment. Right? So who falls in this category? Any skilled worker, unskilled worker, any normal worker, technical person, operational person, clerical person, even the supervisory person, if they have their wages less than rupees 6,500. Right? That is the category. So when we are talking about such small category of people, I mean the people with such small income in their hand, they should not be deprived of their legitimate due. Right? Now there is a person working for rupees 6,000 per month and he has been slogging day out and day night, day in and day out. He worked for few months and the payment was delayed. Even that is a task, right? So they have their dues for pending 2 months, 3 months, 4 months, 10 months, 1 year, 2 year, whatever it is, whatever is the due that has to be paid to them has to be paid in priority at the time of winding up, because those people, they don't have anything to fall back on. A person who is earning 6,000 rupees per month, what do you think? Will he be able to fall back on something? Did he save anything? No. It's a hand to mouth situation. Right? So the law also acknowledges this fact, and they say that if there is workmen in your company, in your industry, then you will have to pay off their dues before paying off anybody else. Right? So now you understand what workmen is. Again, when we go back to the preferential payment, right, there you will come across the term employee. When we're talking about employee, you know that they are not the workmen. The first point of distinction will be that they will be paid somewhere above rupees 6,500. And basically what kind of work they have is the supervisory work, managerial work, these kind of work those people have. They don't have the ground level work, the field work. Right? Though the people who are at the ground level, at the field work, they are categorized into the workman class because they are working day in and day out, and the others are the supervisory class who supervise and make them work. Right? And when we are talking about the workman class and the supervisory class, or whatever these things you're talking about, the law says we will not pay a lot of attention on the contract of what is the designation given in the contract. In the true sense, cognate sense, whatever it means in reality, that is what we'll be checking. So let us not get deep into that. All you understand is workman means labor category. That is it. You don't have to write anything anywhere. You will not be asked any question because the act says that you will have to refer to the Industrial Dispute Act. Right? And that Industrial Dispute Act is not in your syllabus. And if something is not in your syllabus, you will not be asked any question based on that. right? So it was just for your information that now you know it is the labor category people. And secured creditors are all those creditors who have been secured by the pledge upon an asset, hypothecation upon an asset, right? If you go to a bank to take a loan and you have given a land as mortgage, that bank is a secured creditor now. Understand? So all those people who have a charge on their assets, they will be paid in priority to the rest. Why? Because they have given the money and they own this asset on documents. By owning, I don't mean they have the ownership rights, but they have the right to the proceeds that the company would get out of the sale of that asset, right? So if you have already declared, if you already have a contract or an agreement that okay, when I sell this asset, if I have a piece of land, when I'm selling this land, if I'm getting any money out of it, all those money would go to this person. You already have a contract, you have a document, so you cannot forego that contract, right? That is why we're talking about the secured creditor. But again, there's one more thing given in the act, is that if your amount does not suffice the dues that are pending with the workman and the secured creditor, then both of them, they shall abate in equal proportion. We'll discuss what that equal proportion is again when we go to the practical aspect, right? So for now you know what workman is. Now we'll understand what workmen dues are. So workmen dues are basically the wages, the salary, the commission that are earned, including the compensation paid to any workman, right? Again, this compensation word comes from the Industrial Dispute Act. Whatever the Industrial Dispute Act says about the compensation given to the workers, you will include that compensation in the payment. We don't know what the compensation is. We are not interested in what the compensation is, right? Okay. Next is the accrued holiday remuneration. Now what is accrued holiday? It is not a vacation, it is not LTC that we're talking about over here specifically. When we talk about accrued holiday, is those days that were given a holiday but were paid. You may consider it to be a national holiday. You may consider it to be any paid leave given to the workman, anything. But when you talk about accrued holiday remuneration, means those people, they were at home, they were not working, but still that day has accrued and they are liable to get the payment for that day. That is all you need to understand when you talk about the accrued holiday remuneration. And basically, for your exam point of view, you have to just remember the word accrued holiday remuneration, because if they ask you, you may have to write about it. But generally they won't test you on certain things, on such things. If they want a list from you, then they will ask you a list of the preferential payment. Okay, name the preferential payment people. That can be asked, right? But please tell me what all things will be included in the workmen due. That is a very typical and a very specific question going deep into. So when the institute starts digging into it, they come to this point, which they generally do not do. I'm not taking a guarantee you won't have this question, but there is a very, very, very minimal probability that you have a question on this, right? Next, you have the compensation for death or disablement. Now, when we talk about compensation for death or disablement, right, this compensation is due under the Workmen's Compensation Act 1923. Again, that act is out of your syllabus, out of your reach. We don't have to do anything about that act, because if we get into the discussion of that act, we go deep and deep and deep and we waste a lot of time. So let's forget about that. Just remember, it is compensation for death or disablement. But this compensation will not be given if the company is winding up and then converting into a new company. That means it is a winding up for the purpose of amalgamation or merger, right? Again, these conditions have also been given by the act, the other act that we're talking about, the Workmen's Compensation Act, right? So we don't need to understand why and what. All you need to know is the compensation for death or disablement, which will not be paid again in the case of amalgamation and merger, right? And the last is any sum due to any workman from the provident fund, from the pension fund, from the gratuity fund, or any other such kind of welfare fund that they have, or which is maintained by their company. Clear with that? So now you know who the workmen are, what are the dues for them. These things have to be paid in priority. And you also know now what secured creditors are, right? We have discussed about it. But there is one more thing that we discussed, the term pari passu. which means side by side. So when we are talking about the secured creditors, right, and if the example that we had taken, that the loan due is for rupees 100 lakhs and the workman compensation is due for rupees 25 lakhs, and you have a total of 80 lakh rupees in your hand. So how do you decide the proportion? Because you have 80 lakhs and you have 80 lakhs by selling off an asset, and that asset was charged to that creditor. So all this 80 lakh actually belongs to the creditor as per the contract, but you are overriding it, and you say that you will distribute that 80 lakhs among the secured creditors and the workmen in equal proportion. When we talk about equal proportion, doesn't mean 40 lakhs. It is talking about proportion. That means the weightage that the workman compensation has on total and this secured creditor portion has on total. That means the total is 125 lakh. So the proportion is 100:25. So 80 lakhs will be divided into 100:25 and distributed accordingly. Now do you understand what I mean to say? Even if it is not clear now, you will be cleared with this concept when we actually get into with example, into a little illustration with this. Or forget about the illustration. When we are doing the question, I will discuss a question from your examination and from your practice manual. When I talk about a question from your examination and your practice manual, doesn't mean I'm talking about two questions. I'm talking about a common question that has appeared both in your practice manual as well as your examination. Right? We'll discuss one question, and over there you will know what calculation are we talking about. Right? So far, let us move ahead with understanding who the preferential payments are. Right? So we start with section 530, the preferential payments. Okay? So the first that we have is the revenue, taxes, cess, rates, etc. So basically, whom do you pay these things? You pay to the government. Right? The act says we are indifferent whether it is the central government, whether it is a state government or any local authority. When it comes to government, you have to give them a preference over the other unsecured creditors and the rest in making the payment in the course of winding up. Right? Again, you remember when we were talking about the winding up procedures, right? May it be compulsory winding up, may it be voluntary winding up, maybe by the members or the creditors, or the winding up subject to supervision of the court. Any mode, I don't care about it. You have seen that the liquidator, when he takes charge of the office, within 30 days he sends two notices, if you remember. One was to the registrar that yes, I have taken charge, and the other is to the income tax officer. Why? If you have any dues, let me know. And within 3 months they revert back, and then he puts aside some money. So this is where that money is utilized. Whatever dues are there, those dues will be utilized. All these details he doesn't get, right? But he knows that yeah, within the past 12 months from the date of winding up, whatever is the due or whatever is the tax cess rate that has accrued to any of the department of government, I will set aside those amount for payment in the case of winding up. Right? Now do you understand what we're talking about? Always remember, it is just about the 12 months before the relevant date. If there's something lying for long back, had to be paid, but because of some dispute or anything it wasn't being paid, you will not pay them. You are not liable to pay them in a preferential payment scheme actually. After you have paid to all the other preferential payment, yes, you can pay them. But whatever tax, cess, revenue, rates, whatever has accrued in the previous 12 months from the relevant date, you will have to pay them in the preferential payment. Right? Next you have the wages and the salaries of the employees. Now when we talk about employees, you know that they have a salary of more than 6,500. Okay? First thing. And second thing, that basically the kinds of work they have is managerial and supervisory. They don't go to the ground level technician and the laborers kind of work. Okay? So it is actually a very conflicting thing to understand what is wage, what is salary, who are workmen, who are employees, right? But over here all you need to know is that the institute does not ask you for the definition of any of them. You don't need to explain who employees are or who workmen are, first thing. Second, you will not receive any question whereby a detail of employees and workmen have been given and you need to segregate who will be receiving what amount in advance and who will be standing in the preferential payment line. No. Why? Because that distinction will basically depend on some other act, and that act is not a part of your syllabus. And if it is not, the institute will not consider, right, will not think, will not deem that you will go and read those acts and draw a clear line of distinction. So please avoid that. Just remember, we're talking about employees, then they are in the preferential payment division. When we talk about the workmen, they are in the overriding preferential payment division. That is it. That is all you need to know, right? So when we talk about the wages and salaries of employee, what all things are covered over here? Over here you include all kinds of wages and salary. Maybe it is payable on time basis, on the piece unit basis, salary on the fixed monthly income basis, whatever it is, commission basis or whatever. If it is salary or if it is wage to the employee, then they will be covered in the preferential payment. So whatever the employee receives. But the point is that, for example, like in the Kingfisher case, they stopped giving salaries to their employees. You all know about the Kingfisher case, right? So what happened over there? It went on, overdue, next month and next month and next month, and it went on, right? So in that situation, if your employees did not get the payment, for example, for the past 1 year, right? So do you accumulate all that amount and give it? Because your employee expenditure, your salary expenditure is a major hit in your P&L if you refer to it. If you have seen any financial of a company, basically, then the employee expenditure is huge. Salary, that means salary of the MD, the directors, the managers, senior managers, everybody. They draw huge salaries in the company. And when you accumulate the salaries of an entire year or 2 year, like people who are earning 50-60 lakh rupees per annum in the higher management, how much money do you need to segregate? How will you sell the assets and get that? That is huge, right? So the Act has laid down a limitation on this, that the maximum period for which you would be considered in the preferential category for your salary due is 4 months out of the preceding 12 months, right? So 4 months in the preceding 12 months. But again, this was not enough, because even 4 months can be huge amount for certain employees at the very high ranking position, right? So they say that in that case, the amount that is payable to the employee should not exceed the amount that is notified by the central government in the official gazette. That means even after putting a ceiling on the 4 months, you don't go beyond, which means you don't go beyond the amount that the CG has prescribed. That okay, if you're talking about 4 months also, this is the limit. But again, over here it becomes a little conflicting situation. Why? Because currently the notification that you have, right, the notification that is applicable for you, the notification number GSR 80E, right, which was again issued back in 1997. 1997 means it's around 20 years now, and we are still having that notification applicable. Don't you think it's wrong? What about the time value of money? What about the inflation? What about the decrease in the value per rupee? Right, we didn't consider that. 20 years back rate is still being continuing, and the notification says it is 20,000 rupees. That is it. So this notification itself is contradictory to the entire concept, because when you talk about 4 months, and if the employee category is into the category of people who receive how much? More than 6,500 rupees per month. So into 4, it is already 26,000 rupees. And CG says maximum 20,000 rupees. So what do you mean to say? Are you talking about employees or are you talking about the workmen? It's a conflict. We don't know. All you need to remember is 4 months in the past 12 months and rupees 20,000. Now you will not forget the limit of 20,000. Why? Because anytime you have the confusion, you would just refer back to the example I have given, that it is not a valid limit. How can it be? Logically it is not valid. Logically it does not exist for the employee category. It falls into the category of the workman as per the slab, right? So with this example, why do I give such example? Why do we need to draw such comparison? Is that you understand and you keep it down your head. You don't need to mug up everything, right? In the beginning of the lecture, the previous class, I told you, I would make an attempt that you remember all these things. That is why for revenue rates and taxes, we referred back to the notice that the liquidator gives. and you know that yes, it's a preference. The wages, salaries, you know it's a preference, because if workmen are given, even the salaries will be given. But again, the limits have been set. How to remember the limits? I've already told you. Right? So next we have the holiday remuneration to employee. Again, the holiday remuneration is the same thing that we discussed in the workman compensation. It is the same category, but over here we are talking about the employee. Right? And we are talking about those holiday compensation that was payable to the employee before or by the effect of the winding up order, not after that. Because they are sent on holiday after that. The power has been taken up by the liquidator. Directors and everybody, they discharge their office. So again, they're on holiday. So you won't say that, yeah, these are their holiday remuneration that they're getting. Right? So this is how you remember the date. Next, your employer's contribution. So when we talk about the employer's contribution, what contribution your employer makes, apart from giving you salary, is the contribution basically that he makes in the other funds, where it is mandatorily required by those acts and those laws. Right? But over here, the CG says that, or the act says that no. You don't have to return back all the employer's contribution, wherever in PF or everything, you can't call them back. What you do is, if there is anything that has been due to you in the past 12 months that you were already supposed to receive, any of the employer's contribution, those contribution would fall under preferential payment. Rest here you can take it even afterwards. Right? Your PF, you can withdraw your PF anytime. So those things will not be considered over here. But employer's contribution, when we talk about, is that employer was supposed to contribute in your PF but did not in the past 12 months. So whatever amount he did not, he'll have to give it to you or pay it over there. Crux says you need to receive it. Right? Next you have the compensation to the employees. Now when we talk about the compensation to employee, again we are referring to the same compensation that was referred in the case of workmen, which fell under the Workmen's Compensation Act 1923 in the event of the death and disablement. Right? Again, the same provision applies, that they will not fall due if it is a voluntary winding up merely for the purpose of reconstruction or amalgamation. Otherwise, employee compensation would be received by you. Right? Next is the sums due from various funds. Now, what are the various funds from which you receive the fund? That can be your provident fund, your pension fund, your gratuity fund, or any other fund for the welfare of the employee, similar to the workman compensation that we are talking about. Sum due to the workman. Right? And at last you have the investigation expenses. Investigation expense is the expense that has been borne for certain investigation made by the liquidator. Right? All those things are in priority. If they are making the expenditure for this investigation, they have to be paid in full, in priority, and then for the next of the things. Otherwise, they won't make the investigation. They know company is going for a toss. We go on for investigation and again stand in line. Who will go? Let it be. Right? That is why you have to pay them. Yeah, come on. If they're coming for investigation, they'll have to be paid on time. That is why they'll come. Otherwise, they will not come, because they already know the company is going to be wound up. And if they have to stand in the line at the end, they will never come, because they know that they are not in a situation that they'll be able to pay. That is why these investigators are being called. Why do you want an inspector for investigation? Right? So basically, there are few things that are common from the workmen due concept, that is the wages, salary, holiday remuneration, employee contribution, and the sums due from various funds. And otherwise, you have to remember just few more things, that is the revenue, taxes from the notice sent by the liquidator. You will remember this, the employer's contribution, because for those wage category people, you don't have such employer's contribution. You have it for the employee category, basically, right? I'm not talking 100%, but basically. And the last one is the investigation expenditure. Right? So with that, we have discussed the list of the preferential payment. There are little more to go ahead, but we'll take it up in the next lecture. And in the next lecture, you remember, we'll discuss the practical aspect and the question from your practice manual and the examination. So until then, this is Abhinay Gupta signing off. Stay tuned for the next class. Thank you and bye-bye.